Okay, I think we're on.
Hello.
We're going to just wait till the music ends. There we go. Ready?
Okay, I think we're ready. Welcome everybody to the first of our estate planning webinars. We are using this format to both get some basic education out to the community about estate planning and also as a promotion for our estate planning offerings, which we'll talk about at the very end of the webinar. As we get started, I want to just make a couple of announcements first, that this is really intended just to be an educational seminar and not specific legal advice. We'll do our best to answer your questions, but again, until we have a lawyer-client relationship, we're not giving specific legal advice. You have a chat box to the right of your screen, and if you have questions along the way, if you type your questions into that chat box, we will either address them right away on the spot if we can. Otherwise, we will do our best to answer all of the questions at the end of the presentation. So with that, I'm going to ask our moderator to go ahead and, or maybe we should introduce ourselves first. Sorry, I forgot about that. I'm Kate Kilberg. I'm one of the partners at Catalyst Law. And my career over the last 20 years has been primarily estate planning and nonprofit work. And so I will be one of the presenters and answering questions today.
And I'm Kimberly Pray. I'm Kate's law partner, and I have been practicing for more than 10 years, working with Kate for the last 5. And specific to estate planning, I have an LLM in tax, which is a master's in tax law. So we're a good team. We have a wonderful paralegal working with us, and we can't wait to get started and let you know all about the basics of a good estate plan today. Okay, so why don't we just get started, Kate, with some statistics?
Sure.
So
do we have the slides up, or they're not up yet?
They're not up yet.
Okay.
So just to kind of give some background, you know, a lot of folks believe that having a will is important. A recent poll by caring.com in 2019 identified that 76% of Americans think that having a will is important, and 90% of respondents to that poll said that they wanted to make their deaths as easy on their families as possible. But yet 50% of those polled had talked to someone about making an estate plan, but only 40% had actually done so. So there's always, in these types of polling, it's at least 50% of the public or more that has not gotten around to estate planning. So you're not alone. And if you've done it before and you want to update, that's great. And we're going to talk about when you want to think about updating your estate plan later in the presentation.
So getting back to those statistics, as Kimberly said, about 50% of people have not talked to anyone, even though they've thought about and they think doing an estate plan is a good idea. And we have these statistics that I think are interesting, in that 50% of that 50% basically say that they just haven't gotten around to it. And then another 21% of that 50% say that they don't have enough money to be concerned about estate planning. And then the remainder of that 50% is a mixture of they don't have anyone to leave assets to, they think estate planning is too expensive, they don't know how to get started, or other. And so part of what we've really tried to do with our estate planning team at Catalyst is make estate planning as easy as possible. And so along one of the features that we've done is that we've gone to mostly fixed fees for estate planning engagements. To the extent we can, we want to be offering a fixed fee engagement. And for one thing is that it's much more predictable for you as the client. You know what it's going to cost up front. There's no hidden costs. You know, we don't produce a wonderful estate plan for you, and then you get a huge bill that sort of sours you on the whole process. And so, so that's one of the things that we're trying to do, is we're trying to really help you get around all of these reasons why you may not have an estate plan yet. So you haven't gotten around to it, or you think it's too expensive, or you don't have enough to worry about. We've really tried to make our process as streamlined as possible. And so we're going to jump into what the basics of an estate plan are. But before we do that, I do want to just talk a little bit about the process that we have designed at Catalyst, because it is kind of unique. I'm not aware of any other firm that does estate planning the way we do, or through the process. So we have designed a process of 3 meetings. So if you were to choose to work with us for estate planning, we'd have an initial meeting. And while we're all on pandemic stay-at-home orders, we're doing those by video conference. And that's the first meeting, is really for us to get to know you, get to know what's important to you, get to know who your family members are, what you're thinking about, what your assets are, and what your asset values are. We do a little bit of education in that first meeting so that we help you work through some of the decisions that we need you to make. Then the next step is we go back and we draft all of the documents for you. We send those to you electronically. And then a week or 2 after you receive the electronic documents, then we have a second video conference, or in a normal situation, we would do an in-person meeting. And the point of that in-person meeting is to go through the documents together, answer any questions that you might have, and make any changes. So if we got something wrong, if we spelled somebody's name wrong, or we didn't get their address correctly, or maybe you had intended to give, you know, a certain amount to a certain person and we didn't quite get that right. In the second meeting is when we discuss all those changes. Also in the second meeting, we go through the process of coordinating your estate planning documents, which are generally a will or a will and a revocable trust, which we'll get into in just a minute, with all of your other assets. So things like retirement benefits and life insurance don't actually pass through a will or a revocable trust. So also at the second meeting, in addition to reviewing the drafts, making sure that they look good, that you understand them, that everything is correct, we also look at all of your assets, and we try to figure out what else do we need to do to coordinate the way you own your assets with your estate plan. And we'll go into a little bit more detail about that as well in this presentation. And then at the third meeting, so then we go away again, we make any changes that we need to with respect to the forms that you've identified. And then if there's anything to be done on those beneficiary designations, or maybe there's a real property deed or a business assignment, we do all of those documents. And then you come back for the third meeting. And after the third meeting, you sign everything and you should be done. And that should hold you hopefully for a long time. One of the things we do that's really unique is that part of our fixed fee includes a 2-year follow-up meeting at no additional charge. So every 2 years, we reach out to you and we say, hey, have there been any changes? Have you bought or sold any assets? Have you added to your family? Most of the time when we're doing those meetings, there really aren't a whole lot of changes, but sometimes there are. And if there are, then we would make the changes at that time and charge only for the time needed to make the changes. So we really like doing that. It lets us keep a track of you and make sure that when the time comes that your estate plan is as up to date as possible, that we haven't forgotten about a new beneficiary or a new asset. And so that's sort of the process. Now I'm going to turn it over to Kimberly, and we'll go down to the next slide, and we'll start talking about during that process, what are the deliverables, what are the documents, what are the pieces that you would come away with that estate planning, with an estate plan after you go through that 3-meeting process with us.
Okay. So can we have a slide change here? Awesome. Okay. So the basics of a good estate plan include a revocable trust and or a will. And we'll go into the details there, but the differences and the considerations you make when selecting trust and or will. A durable power of attorney, which is financial decision making. An advance directive, which in Oregon is a statutory form required by the state, and that is your healthcare decision-making document. The HIPAA waiver, which is the federal healthcare information release, so that the folks that you designate as your representatives are authorized under HIPAA to view your medical records. We cover life insurance, beneficiary designations, and form of ownership. So, and then the next slide goes into the will. So the will is a document that directs how your assets are distributed at death. So they also designate people to both care for minor children or other dependents that you may have, handle your business affairs, and handle your property. And so with a will, you need to go through probate to pass the assets from your estate to your beneficiaries. So after your death, the probate process is how that happens. In Oregon and Washington, the process is fairly straightforward, but it can take some time. So on average, 9 to 24 months. And in this current environment with the courts closed and a big backlog that we're expecting when courts actually open, I could see that actually taking longer. So depending on the estate, costs for court fees, legal services, and administration tend to range anywhere between $5,000, which is the very low end, to $50,000, which for estate plans that are that have there's high value assets or complex assets, or things just aren't organized very well, that actually tends to drive up the cost. In the event of your disability or incapacity, a will does not enable someone to step in to assist with the management of your affairs. So it's important to always have a power of attorney if you're relying on the will as your document to pass assets after your death. The most important folks in the will are the personal representative. So naming the personal representative is the person who manages the administration of the estate. That's also referred to as probate. So in Multnomah County, the personal representative actually needs to complete a course that's mandated by the court about fiduciary duties and your responsibilities under as that fiduciary. And then the other consideration in a will is the appointment of the guardian for any minor children. And that person is responsible for taking care of the child's physical, emotional, and spiritual needs, but may not be the person taking care of their financial needs. And so whether or not you need a revocable trust is really both a personal decision and a function of whether you're married or single, and what your potential estate tax burden would be. Oregon has a very low exclusion amount for Oregon state estate tax. So even if you don't come near the exemption for federal, which is more than $11 million per person at this point, in Oregon, it's very easy to meet and exceed that $1 million exclusion. So the primary reason you would choose a revocable trust would be to avoid estate administration. So avoid probate is one of the reasons. And the other reason would be privacy. Kate, do you want to talk a little bit about the privacy considerations?
Sure. So generally, the only thing that a revocable trust does, you can think of a revocable trust as just a substitute for a will. It doesn't do anything in terms of changing your tax status while you're living. And it doesn't even really change your tax status at death. The only thing it does is keep you from having to go through probate. So when you die, in order for your assets to pass to your beneficiaries, however they're determined, generally there's this court process called probate, which is how those assets get retitled and title gets transferred to the next owner. The revocable trust, the reason you would use a revocable trust and why you might want to avoid probate is, as Kimberly mentioned, there are delays associated with probate. So normally when we're not in a pandemic situation, it can take 2 to 4 weeks just to get a probate started, somebody appointed as a personal representative. And so during that time when you're waiting to be appointed as the personal representative, you still are going to have bills to pay on behalf of the decedent. So you're going to have funeral expenses, probably expenses related to their last hospital bills. And what the delay means is that the family needs to pay for those expenses, and then they can be reimbursed once the estate is open. But for that 4 to 8 week period, while we're waiting for somebody to get appointed and be able to get access to the decedent's assets, generally it's a family member who's paying those bills. So that's not ideal. If you had a revocable trust, on the other hand, once the person dies, immediately the successor trustee steps in and has the authority to access the decedent's assets and can use those assets to pay those funeral expenses and expenses of last illness. So that's one reason. And then the other reason is, as Kimberly mentioned, is privacy. And so a probate proceeding, in addition to being sometimes just a delay, is a public proceeding. So when we do a probate, we file your will, we file an inventory, which is a listing of all of your assets. And so pretty much anyone anywhere can look up, get onto the court system and look in and figure out what you owned and who's going to receive it. And it's not a common occurrence, I wouldn't say, but there are cases. There was a movie, it's probably 15 years ago now, called Catch Me If You Can with Leonardo DiCaprio. And the guy who that movie was based on, the way he would find the people that he would go and rip off, basically, was he would go through probate records and figure out who had just inherited a bunch of money. And then he'd go become their best friend. And so, aside from just the idea that you might personally not want your personal affairs, out in public, it also protects your beneficiaries to some extent to not have that publicity of who they are and what they're going to be receiving. And then the third reason why I would sort of lean in favor of doing a revocable trust for somebody would be if you own real estate in more than one jurisdiction. So you would need to do a probate in every jurisdiction where you own property, where you own real property. And you can avoid that by just doing everything in a revocable trust, then you wouldn't have any probate at all. So that's why I would recommend a revocable trust versus a will. We do have in the handout section a handout that goes into more detail about wills versus revocable trusts in Oregon. So you're welcome to take a look at that and download it if you have any other questions.
Okay, thank you. So the next very important piece in a comprehensive estate plan is the durable power of attorney. And the power of attorney plans for the event of your incapacity. It doesn't plan for death. And so what you're doing with the power of attorney is you're naming an agent to handle your financial and property matters while you're still living, but unable to do so yourself. So that might mean that maybe you're traveling and you have to close on a home and your spouse has power of attorney and can sign on your behalf. or maybe, you're in a coma and someone needs to make some changes or make a gift to make sure that your estate taxes are minimized and that you continue with your estate tax planning even though you're incapacitated. So the power of attorney is critical for a comprehensive plan. And there's two types. One is springing. So the springing power of attorney is effective only on proof of your incapacity. And the non-springing, the other power of attorney, is effective immediately when you sign it. So you need to make sure that both the provisions in the power of attorney are appropriate, that the person that you're naming as the agent should have all of those powers, and then decide whether or not you're comfortable with a springing or whether you'd prefer a non-springing power of attorney for who you're naming as your agent. And that person has the authority to act on your behalf. And so if they needed to do something, make a transaction at the bank, they would need to present that document in order to do so. So with that, this is the those three documents: the will, the revocable trust, and the power of attorney, really are what handle your finances upon death or incapacity. And the topic that we wanted to focus on today, with running through our advance directive form, is the document where you're making your decisions about healthcare. And so sometimes this document, the advance directive, is referred to as a healthcare power of attorney or a living will, which also gets confused with a revocable trust. So the terminology here is sometimes confusing, but in Oregon, you have to use the Oregon form, and you have to it's for two functions. One is to name a healthcare representative to make healthcare decisions for you if you're incapacitated. And then the other function it serves is to allow you to state your wishes about life-sustaining treatment if you're close to death. So we'll be going into the directive in a lot of detail, considerations that you'll want to make with the documents in the your basic estate plan. The HIPAA privacy waiver, I think I mentioned this earlier, is what is used to authorize the doctors to release your medical information. So it's necessary to accompany the advance directive. And then beneficiary designations, so as Kate mentioned, are the documents that control, so if you have a life insurance policy or a retirement plan, you're probably familiar with the section that asks you to name those beneficiaries. And that's because wills and trusts don't govern what happens with beneficiary designated assets. And there's really complex tax rules that come into play when you're benefiting a non-individual, such as a trust, or when you're needing to leave those assets to charity. There's many different options with retirement accounts and life insurance policies. So we really want to be able to coordinate that with your basic estate plan. Kate, is there anything you want to say on that?
I don't think I have anything to add there.
Okay. So next slide is just more about providing for minor children. So in providing for a minor child in a will, naming a guardian is going to ease a transition for the child. You're going to want to appoint someone with similar values and child rearing philosophies. This allows you to really express your wishes to those people that you appoint as guardians, in terms of letting them know why you selected them, why you think they'd be a good choice to raise your children when you're unable to. And but that does not mean that you're actually leaving assets to that guardian. So you can pick someone who is going to be the best for their emotional, social well-being, but may not be a great money manager. And you can appoint someone else to actually manage the finances for your children. So there's a few ways to leave assets to minor children. One is a direct gift, which we do not recommend. And that's because it will probably result in a court-monitored guardianship. So the other options would be the Uniform Transfers to Minor Act and through trusts. So we talked about that earlier, but you can do it in a will, so you can have a testamentary trust, or you have a revocable trust and a grantor trust, and that again provides the privacy and flexibility in that financial management.
And just to be clear, there are several different types of trusts. And so the revocable trust that we were talking about earlier, that's a will substitute. That's an inter vivos trust. That's a trust that you set up during your life. Inter vivos is Latin for during life. And then the testamentary trust is the one that is a trust that comes into existence when you die. So you can have a testamentary trust either in a revocable trust or in a will. Testamentary just means that it comes into existence upon death. Okay, let's go to the next slide. Okay, we mentioned that we're talking about what should be in a good estate plan, and I just also want to point out that there's this list is also in a handout on the right side of your screen, so you can also have that and print it out and take it with you after today's presentation. But in addition to all of those documents that we just talked about, a good estate plan will also consider how you own all of your assets. So I think one thing that sometimes surprises people or people get caught with is how they own their assets. And so, for example, your house. Do you own it? Do you own it jointly with your spouse? Do you own it jointly with somebody else? And then any other real estate assets, do you own that as part of a business? Is it in an LLC? What does that mean? We had one case a few years ago where it was a partner and the husband had a child from a prior marriage. And he had repartnered with another woman, and they had not remarried, but they were living together in a house, and they had bought the house together. But because they weren't married, the house was titled something called tenants in common. And he died unexpectedly without a will. And turns out she now owned her house half with his son, who, to make things even more complicated, had a drug problem and was really difficult to locate. So this is one of the things that a really good estate plan will think about and will look at, is how do you own all of those assets, all of those things that are yours, and what implications does that have for how they will pass upon your death? This also looks at your retirement benefits and life insurance, which we've mentioned a few times are not covered by a will or revocable trust. So you really want your estate plan to be considering the big picture of all of those things, and how that will affect A, who receives those items upon your death, and then B, how they'll be taxed, if at all. Anything else on that, Kimberly?
No, I don't have anything else.
Okay, let's move to the next slide. And this slide is just a last thing. So what we've been talking about today is sort of a very basic estate plan, an estate plan that's really just geared toward covering and giving direction for what should happen upon your death. There are certain situations that would require a more complicated estate plan. And so those situations, just to make you aware of them, is if you have a child with special needs, if you own a business, those second marriage situations, particularly with children from a prior marriage, those can get complicated. If you've got an inheritance from an older generation, and so you've got family trusts that we need to consider along with your overall estate plan, that can make things more complicated. And then moderate to significant net wealth. So we'll need to, Kimberly mentioned that in Oregon, each individual has a $1 million exemption from estate tax. And, you know, with real estate values where they were, at least pre-pandemic, and life insurance policy, it's not hard to get to that. And so you want, if you're in that category where you individually have over $1 million, when you're considering life insurance and real estate values, we're not just talking about your liquid assets and cash, then we need to start thinking about tax planning, estate tax planning. All right, let's flip to the next slide. So as I mentioned early on, part of our fixed fee program is that we check in with you every 2 years. Just again, because we want to keep up with you. We want to make sure that when the time comes that your estate plan is as up to date and consistent with your intentions as possible. But we also like to point out a few things when you should call us if there's a change. So I'm just going to list some of the things on the slide. So if there's a change in your marital status or the marital status for any of your children or grandchildren, beneficiaries, if you welcome a new child to your family through birth, adoption, or marriage, if your spouse or a family member has died, become ill, or incapacitated. And that's actually twofold. So we're happy to help with the estate administration for that person if they're in Oregon or Washington, but also it may affect your own estate planning documents if they were a beneficiary or named as a personal representative or trustee in your documents. If you move to a different state, if there's a substantial change in the value or character of your assets, if you start or sell a business. So next slide, please. So just continuing on along the slide, on a second slide, you also want to get back in touch with us if you receive a sizable inheritance or gift. If you're wanting to make a gift to a charity. So sometimes we can help you think through the way you're wanting to give and to make it the most tax efficient. You're considering purchasing a life insurance policy. You become aware of changes in the law. Your documents are lost or destroyed. You probably need to get those replaced. Mm-hmm. And then 2 to 5 years since you last reviewed your plan. So again, we'll get in touch with you every 2 years. But if you don't hear from us and you're worried about it, feel free to get in touch. We're always happy to hear from you. That may be the last of our slides for today.
That's the last slide. We do have one question. What is considered a jurisdiction? Is it a county or a state?
Oh, that's a good question. I think that question came in when I was talking about whether you would need to probate in multiple jurisdictions for real estate. And what I meant was states and the District of Columbia. So I practiced in DC for most of the early part of my career. I guess not most of anymore, but the early part of my career. So I got used to saying jurisdiction since the District of Columbia is a district. And actually Virginia is a commonwealth. So there you go.
Yeah, so there are different types of jurisdictions. So there's state jurisdictions that come into play, but then there's the jurisdiction in where you file a probate. And so that's where you live or where the person passed away. There's a couple other options as well, but so you could have lived in Washington County, but died in Multnomah County, and you have the choice of jurisdiction, which county you want to file probate in. And that's actually come in, it's been important in the COVID era because Washington County courts, for example, have gone dark with respect to all probate matters. They're not handling any new matters. Whereas Multnomah County is still taking and filing in their probate court. And so because of that, we've been able to move along a case and using Multnomah County probate court, using that jurisdiction as opposed to Washington County. So you're going to look at county jurisdiction as well as state when you're thinking about probate.
But for purposes of the revocable trust versus a will question, and real estate ownership, we're really only talking about different states.
Yeah.
Okay, so at this point, we thought we would go ahead and walk through the Oregon form. So you're welcome to look at the handout that is posted on the right side of your screen. This is a form. So the form is dictated by statute. So this is a document that we've put together from our office. There are multiple other places online where you could also get this exact same form. And so we'll go ahead and pull that up and then and just kind of walk through it. And Meg, moderator, I don't know if you're able to open it up and then and do a screen share like you were doing for the PowerPoint, if you can. Thank you.
Okay. So this will just give you a chance, if you haven't already, to go to the handout section and download the Advance Directive. It looks like several of you have done so already. So you have your own copy. And then we're just going to walk through and provide some guidance. And as we're doing that, please feel free and chime in on the chat, and so that we're clear on what questions you may have. This is not the most straightforward form to understand. And do you just full screen with that, Meg?
And while we're figuring that out, I'll just let you know that Oregon is really unique in the fact that there's this statutory mandated form. So as I just mentioned, when I started practicing, I was in Washington, D.C., and so I was working with Maryland, Virginia, and D.C. clients. All of those jurisdictions, there's no prescribed form. You can pretty much write whatever you want about what kind of treatment you want, what kind of care you want. And as we get into this form, you'll see one of the reasons I prefer the sort of write whatever you want form is it honestly ends up being less confusing. I think that there are things about this form that are confusing, and I think that there are things that could be answered one way and meant another. So we'll point those out as we go. But we live in Oregon. We love Oregon. So here we are. Here's the form.
So in the form, we've left a blank at the very top of the page for you to fill in your name. So that's why the line is there. Typically, if we're working with you on the Advance Directive, that would be typed out. Okay, so the first section is About Me. And the About Me section is just for you to put in your name, date of birth, the telephone numbers that you use, your mailing address, and your email. The second part of the form is to name your healthcare representative. So you're going to need to fill in all the information that you have, as well as that person's relationship to you. That will be the primary healthcare representative. And if that person is not available, then the form provides you with options to appoint alternate healthcare representatives. So this form has up to 3 available. And if you want to appoint more, we can always include those as well. So you would fill out the alternates. And typically this is a position that you may want to consider who you would trust locally or within, someone who could get to wherever you were quickly to make those healthcare decisions rather than someone who might live across the country. So in this day and age when our families are spread far and wide, there's a chance that, that healthcare decision would have to be made and the person who's appointed may not be close at hand. So that's something to think about when you're appointing a healthcare representative.
So another thing to point out here, and a common question that we get is, for example, if you have 2 children and you really want them to be making the decision together. So this form, in the form that it comes in the statute, it doesn't really allow you to do that. One of the things that we will do as part of the representation is, so the statute says that the Advance Directive has to be in substantially this form. And we think it's okay to modify the form to name 2 people to act together. You also can, pick one person to make the decision and then sort of write in that you want them to consult with, another person or a group of people before they make their final decisions.
So Section 3 is instructions that you provide to your healthcare representative. There's 3 choices. One is saying that to the extent appropriate, my healthcare representative must follow my instructions, or my instructions are guidelines for my healthcare representative to consider when making decisions about my care. So this section dovetails with the following section about end-of-life care, because this really is where you are going to either rely on your healthcare representative to make decisions on your behalf, or you're going to direct your healthcare representative to follow your wishes as you've instructed on this advance directive. And so we also have other instructions, and that's an area that you can initial and then provide an addendum, another piece of paper attached to the document if you have additional instructions. Kate, we have a question from a participant. Is this form honored in other states? Meaning, if something were to happen while traveling or working out of state, will this be accepted?
It should be. I mean, so this is one of the things about these forms and why I prefer not having forms and having you just be able to have a statement is so what I would say is most states don't have a required form, so they would accept this form. So it's state dependent. I believe there are 5 states that have some sort of requirement. So as long as you're not in one of those 5 states, and maybe Kimberly can talk about the next section, and I can look up and see which of those states might have a requirement that would not accept this form. But if you're in a state that does not have a requirement, I can't think of any reason why they wouldn't honor your wishes as expressed in this form.
Yeah. Okay, thanks.
Mm-hmm.
So after you've kind of pondered whether or not you want your healthcare representative to follow your wishes, or you want your wishes to serve as a guideline for your healthcare representative, then in Section 4, you're going to, you want to be real careful reading the directions about the end-of-life care. The term "as my healthcare provider recommends" means that you want your healthcare provider to use life support if they believe it could be helpful, and that you want your healthcare provider to discontinue life support if your healthcare provider believes it's not helping your condition or your symptoms. Life support means any medical treatment that maintains life by sustaining, restoring, or replacing a vital function. The term tube feeding means artificially administered food and water. If you refuse tube feeding, you should understand that malnutrition, dehydration, and death will probably result. Just a reminder that you'll receive care for your comfort and cleanliness no matter what choices you make here. So the statement regarding end-of-life care is, if you agree with this statement and you don't have specific instructions for all of the various choices under Section B, 4B, the additional directions, then you can initial this section and call it good. So this is saying that you don't want your life to be prolonged by life support, and that you don't want tube feeding as life support. You want your healthcare provider to allow you to die naturally if they confirm that you are in any way in any of the medical conditions listed below. So then going down through those medical conditions, the first subsection is little I, close to death. So if you're close to death and life support would only postpone the moment of your death, then if you have a specific consideration that you want to receive tube feeding, or if you only want to receive it if your healthcare provider recommends, or if you do not want tube feeding at all, whether or not it's recommended or indicated. And that's when you're close to death, where it would only postpone the moment of your death. This also gives you the option to indicate that you want any other life support that may apply, that you want life support only as your healthcare provider recommends, or you don't want any other form of life support. So, these are all very, very personal decisions. Again, if you go back to paragraph 3 of the form on page 2, you've also indicated whether or not your healthcare representative must absolutely follow your instructions, or if the instructions or guidelines in section 4 here are just that, they're guidelines, and not something that the healthcare representative is mandated to follow. The next condition that's named is permanently unconscious. So if it's very unlikely that you'll ever regain consciousness, then again, you go through and you indicate whether or not you want tube feeding or any other life support. The third condition is advanced progressive illness. So that's a progressive illness that will be fatal and is in an advanced stage. And you're consistently and permanently unable to communicate by any means, swallow food or water safely, care for yourself, or recognize your family and other people. And it's unclear whether, very unlikely that your situation or your condition would improve. So again, these are very kind of gray areas, but I think that the legislature really wanted you to consider all of the potential options where you would find yourself unable to communicate your wishes. And the final condition is extraordinary suffering. So if life support would not help your medical condition and would make you're suffering more permanently and in severe pain. So again, each of these options is different, but if you are very clear about your end of life care, you can avoid having to go through all of the choices in B and just initial the subsection A.
And then did you talk about C there, Kimberly?
No.
Okay. So C is kind of allows you to do what I've been advocating for. And we do have some clients who just really don't like this form and they do want to write out their own statement. And so you can opt not to fill out parts A and B and then just attach your additional instructions with your wishes to this form.
So just in your comment, Kate, that the following states have specific rules for advance directive and the Oregon form may not satisfy those requirements. You've listed Oregon.
Yes. So yes, sorry. The Oregon form will satisfy the requirements of Oregon law. So take the Oregon out of that.
But if you are in Indiana, New Hampshire, Kansas, Ohio, or Texas, they have their own specific rules that the Oregon form may not meet. if folks are in Oregon from other states, I think that that's also indicates that Oregon may not follow, may not and it's always you know, the decisions of the doctors whether or not to follow these documents, but they may not follow a healthcare directive that's not in the Oregon form if you are in Oregon. So this document is either when you signed, it's either notarized by an Oregon notary, or you have witnesses who witness the signing. So there's an option between the two, and then on this following page, the form asks for acceptance by your healthcare representative. So for those representatives that you name, then you need to reach out to them and have them acknowledge that they've accepted that that's going to be their role. And typically in an engagement with Catalyst, we would send these acceptance documents to those healthcare representatives for them to sign and return to our office. So we take care of the logistics there. And that is all. Kate, do you want to talk a little bit about what we're doing in the time of COVID for those signatures?
Sure. So we're having to adapt, just like everything else going on with this pandemic. So the hardest thing to do is having a will executed, because there is law out there that the witnesses have to be in the presence of the person executing the will, and there are cases that say that means physical presence. So a video call or a telephone call is not enough. With the Advance Directive, so part of our intention here was to give you the form so that each of you could go and fill it out and get it signed and witnessed. Of course, that means that you have to find witnesses that are not related to you and are willing to come within 6 feet of you to sign your documents. So what we're doing as part of the pandemic is, first of all, we're giving a discount on our planning. So anyone who stays through the end of this presentation, which we are almost at, would get 25% off of our regular fixed fee prices for an estate planning package. And what we're offering with that plan is that we will do a virtual witnessing. So again, the law that says that the virtual witnessing doesn't work really only applies to wills. So we would do all of the other documents with a virtual witnessing, and we would have a document that you would also execute along at the same time that says that you understand that this isn't right, that this isn't what we what we intend, but it's the best we can do under the circumstances. And then once the restrictions are lifted and we can actually get together in person and everybody can remain safe, we would have you come back at no charge and execute everything correctly with all the witnesses in place. If that concerns you and you do want to do sort of what would be a proper execution in terms of the documents, we can do that at our office as well. We're just not doing the discount in that situation because it's additional layers of precautions for us to make sure that the room is set up and that people don't come within 6 feet of each other and that everybody stays safe. So to get the 25% discount, we're doing these sort of virtual signings with the idea that if something were to happen before the restrictions were lifted, we would be in the position of having to make an argument that the document was valid, given the circumstances at the time. So the risk you're taking is over the next however many weeks we're all under stay-at-home orders, that something would happen. We think it's most likely that that's not going to happen to most people, and so we'll do the virtual execution, and then when the restrictions are lifted, we'll have you come back. We'll have you come to the office, and we'll do a full execution in person.
So the execution of the witness declaration here could be done by neighbors. So, you can leave a document, they can sign it, you walk back 6 feet, and then they come up and sign it, and then they retreat, and then you get the document. So as long as they see you sign it, they can be 6 feet away. You can maintain social distancing while you're executing the advance directive form. And you do not need a notary. So it's the notary or 2 witnesses that are not your relatives.
And again, just from a legal perspective, I would recommend, even if you're not comfortable doing the sort of social distancing witnessing or a remote witnessing, to go ahead and fill the form out, because a statement of your wishes, it could be respected anyway. Even if it's not technically legally executed properly. It's always helpful for those who are making those decisions to have some sort of direction from you about what you would want.
Right. Okay, so do we have any questions specific to the form itself? I know it's a lot to digest in a very short period of time.
Okay. Well, we, without further ado, we'll go ahead and kind of close off here. I just want to do one more reminder that this is not technically legal advice, and that we are not your lawyers until we formally enter into an engagement agreement. As I mentioned just a few minutes ago, between now and June 30th, we are discounting our fixed fees on estate plans by 25% for people who have participated in this webinar. So what you'll need to do is, when you call and talk to somebody about getting scheduled for an appointment, just tell them that you have sat through a full webinar, and then that will make you eligible for the discount, the 25% discount. We are also offering, if you just have a few questions and you're not sure you want to do a full estate plan, we're also offering 1-hour consultations for $199. Which can be a nice way to just get a few questions answered. And if you wanted to go that route and just schedule the 1-hour consultation, then we would credit that toward any fixed fee if you did end up deciding to go with an estate plan after that consultation. We also, as always, will do a free 15-minute phone consultation with anyone if you have any questions that can get answered that way. And then the last thing I want to announce is that we are doing these webinars on various topics. So in addition to estate planning, Catalyst also has business lawyers, nonprofit lawyers. We have a business litigator and family law. And so I just want to let you know to keep your eyes open in email and on our website for future webinars that we'll be doing during this COVID-19 time. And then the intention is to continue them even after the pandemic sort of subsides. So thanks again to all of you for participating. And we hope that this has been helpful and that you've gotten some value out of this. Please let us know if you have any questions. Meg has done a great job of posting our phone number and email address to write to, and we're happy to talk to you and answer any questions that you might have.
All right, thanks so much.
Thank you. Stay safe.